morning, everyone. My name is Attorney Devin Shanley, and welcome once again to Lunch with a Lawyer. It is great to be back with all of you. I've had a couple weeks where I actually haven't been presenting, which was different and kind of nice. Thank you to Attorney Rousseau and Attorney Schlemmer for coming in and talking, and we are hoping as a firm to be getting and having a few more voices as well, so that is fantastic. I also have lunch again this week. This week, as you saw probably from a couple of the promotions ahead of time, we are from R&D's House Divided. Hello. Uh, I saw a good morning on my screen pop up. So from R&D's House Divided on University Street in Green Bay. It's fascinating because, in Green Bay, there are a lot of Packer bars. In Green Bay, there are, I would imagine, some, but not many Bear bars. And it's very rare to see both a Packer bar and a Bear bar put together in the same place. You think this might cause problems, but it doesn't. In fact, it creates a very nice establishment, which is a fantastic place to go and watch the football season coming up this year because you might not be able to go to Lambeau to watch it. So go to R&D's House Divided. This week I got a chicken Philly, which people that know me will know I tend to like a lot of different things. I'll go for tapas, I'll go for sushi, but when I walk into a bar and grill, I'll order about three things at any given point, and normally the chicken Philly is my go-to item. When we called over there and my paralegal talked to Dee Dee over at R&D's House Divided, she said, "Oh, the chicken Phillies are phenomenal." I was going to something else, and I thought, challenge accepted, and it was well worth it. So amazing chicken Philly, great soups. Go out, check out R&D's House Divided on University in Green Bay if you're looking for a great time, especially if you're looking for a place to go to watch some preseason football this year. Because again, you probably won't go to Lambeau Field for that. So R&D's House Divided, great time. And they're not actually having a preseason game, so watch football games there or the family night game. So today we're going to be talking about something very particular and something that I get asked a lot about that's really tough for people to know what to do, and that is what to do when you suspect child abuse in a case. A couple rules when we talk about this. As always, obviously you can tell I'm a little rusty. As always, please interrupt me. I'll try and say hello as I see comments pop up. I'll try and address questions as I can. But anytime I do see a question, I'm only going to be answering hypothetical questions. Nothing inside of this presentation, no answers that I give are intended to be legal advice that would constitute an attorney-client relationship. Rather, it'll be educational based upon hypotheticals. If you're in a situation where you think, I really should talk to Attorney Shanley about this, or one of the other attorneys here at our firm at Peterson Burke & Cross, please call us at 920-831-0300 and schedule a consultation. We'll be more than happy to sit down, talk with you through the situation, and be able to give you the proper confidential setting to be able to handle your situation because we specialize in you. So with that said, let's talk about what happens. I deal with a caseload that has a lot of unfortunate situations with parenthood. I think a lot of attorneys do. And one of the really common questions that we get asked is, what do I do if this happens, or with a child's, if I really suspect something with a child abuse, or I just don't like what's happening with this kid and I'm really concerned. This is a great question because unfortunately, especially if you're a parent and it's the other parent that's having this, what will happen is you'll get into this weird catch-22 where you might try and report something and you might feel like you're getting labeled as a kook to child protection services or the guardian ad litem. They might discount what you're trying to say. Or if you say nothing and then you say something eventually, they'll go, well, wait a second, didn't you call this at this point? Didn't you call law enforcement? Why didn't you do this if you were really suspecting something or if you were really worried about something? And you kind of get feeling like you're trapped. Well, we'll talk about how we can address these sorts of situations and some basic sort of steps and background to the legal process so you can start to understand what are the rights that you can do, what are the strategies that you can do to start to form this. Before we do this, though, I'm going to have to get up on my legal nerd soapbox for a moment, so I apologize. And we're going to talk another little bit about the constitutionality of parenthood. I choose this topic to start with because that's going to be the foundation for a lot of the assumptions that are built into place when we look at what are the strategies, what are the hurdles, why is the system built the way it is. And to understand that, you have to understand that the constitutionality of parenthood is a relationship. Regular viewers have probably heard me say this before, but it's important to remind ourselves it's a relationship between parent and child. Obviously, there are some rights that the parent has to that about the decisions that they're going to make for the child, how they're going to be treated with medical decisions, how they're going to be dressing, what sort of faith they're going to be raised in. And that is absolutely the call of the parent. That's their rights to be able to do. There's also going to be this assumption that the child is going to benefit from it too. Kids love their parents. Sometimes even abusive parents, even bad parents, the kids still love them. They still want to have a relationship with their mom and dad. And on some level, we as a society still want there to be some sort of mother and father relationship or mother and father like relationship, but we always want it to be safe. We always want it to be beneficial to the child, or at least not harmful. So, where there's always going to be a balance to this, and when this sort of relationship is going to be tested, then we have to be aware of how we're testing it, what sort of legal challenge is going to be presented to that relationship, and what are the facts that we're going to have to prove in order to effectively challenge or limit that relationship. Ultimately, what the courts want, what the law wants, are these happy little bubbles of a nuclear family that's going to be very Cleaver-esque. Mom, dad, kid, and that's it. And if they have that and that's going healthy, then we don't want to intercede. We're not going to want to bother with it. We just want to have that happy little unit. All these different areas of law are breaking apart that unit in various different ways, either because of a divorce or because the parents just can't parent. So, what happens if you see something that is troubling to you? First, you're going to have to assess the situation. Have a good understanding about what is happening, what you are uncomfortable with. Try to be able to articulate this that's going on. Are you seeing bruises on the child? Are you actively watching someone beat a child? Are they just yelling and screaming at the child? Is the child acting in some sort of deeply unhealthy pattern where you have that uneasy in the gut feeling about what's going on? Is there some sort of inappropriate behavior occurring around the child that could be harmful? Really get a sense out of this and try to make sure you understand why you're having that feeling, what you believe is wrong, and really sharpen what that is. And understand, is this something that needs immediate emergency addressing? If it's like seconds and you're actually watching someone beat a child, A, stop the person beating the child. But also call 911, get a hold of the situation. And those situations, if this is emergency right now unfolding in front of your eyes, call the police, call 911. If it's not quite that, if it's a situation that's a little bit more ongoing, deeply concerning, you think, oh my gosh, we got to get this child out of this home, but you're not seeing anything at that exact moment, then the best place to call is CPS. When we're talking about emergency situations, removing children from situations in homes, CPS is going to be the arm of the government that is going to be best equipped to handle that. They're the ones that have the procedures, the social workers, and for the most part, the resources to be able to address that. If this is a situation where maybe CPS has gotten involved, but they haven't quite acted yet, if it hasn't quite risen to that, but you still think it's severe, then you're either going to need to talk to the parent, maybe try to voice your concerns, see if that person can change, or if that relationship isn't there, it's time to consult with attorney because there still might be some legal options that can come out even though CPS isn't quite there to act. Now, if you're going to do that, you're going to need to have facts, you're going to have to understand what the law is and what that process is. So let's talk about that. Whenever we try to disrupt a parent-child relationship, there's going to be a few basic legal styles or challenges or areas or courts that can be able to do that. The most pressing is going to be something called the CHIPS case. CHIPS stands for Children in Need of Protection or Services. It is governed by Wisconsin Chapter 48. As an aside, I should have mentioned this at the beginning, all the law I'm going to be talking about, particularly from this point forward, is going to be focused entirely on Wisconsin law. If you're watching this from somewhere other than the great state of Wisconsin, hello, thank you for joining us. Also, talk to an attorney that is in your locality for what your state's law might be, because it might be different from Wisconsin. If you are in Wisconsin or you have a Wisconsin problem, then hello, keep listening. We'll talk about this. And if you have something that you need addressing, contact us for a consultation. So, CHIPS case under Chapter 48 is what's commonly called the Children's Code in the state of Wisconsin. This is where CPS is removing a child. When you hear people talking about a child being in the system, this is generally what we're talking about. Some sort of foster placement or placement with a relative. And in this case, the design of this is a bit like it's kind of like Humpty Dumpty. The egg or the bubble has broken, and now the government is desperately trying to put it back together with the help of a social worker, which means they're going to be offering a lot of services. Those services are going to come out in conditions to get your children back. So go to AODA treatment, go to anger management or domestic violence treatment, finish up with get housing assistance, get a house, be able to provide for them. Let's see if we can get you a job. And that social worker is both there to monitor the situation, to potentially escalate and move down the path of further taking away rights from the parent, but also monitor the situation to make sure that they can get the child the best place. So work towards reunification or maybe an alternate goal as well. If you are in this situation, I highly recommend you find an attorney that has worked with this in the past. Strategies for CHIPS cases are often difficult, and it's not difficult in the legal spectrum, it's difficult in setting up and taking advantage of the situation to know what to ask the social worker, how to interact, to be able to set up your life in a way that you can start to present yourself as a fit parent so you can work towards reunification. This requires subtlety and this requires a lot of work. And at least even just sitting down and picking the brain of an attorney to know this is a bit what the social worker is looking for, this is what they legally have to do, this is some of the stuff you should do, will be highly beneficial to you. The next is going to be the last thing I want to mention about a CHIPS case is primarily going to be a government acting. So it's going to be the county or the state through its social workers coming in, bringing the action, furthering it, really being the impetus and guiding the action along at every step of the way. If you're in fact not a government action, if this is going to be private, then there are going to be 3 areas that you can look at as well. The most extreme is going to be a child abuse restraining order. A child abuse restraining order is going to be a full restraining order. So at that point, the only thing the court can do is come in and say, you cannot see this child, and if you do, we will put you in jail. That is a criminal violation then. Typically, they last for up to 4 years. So if you have this, especially with a parent, that is probably the most extreme order that a court can prepare to protect a child from an individual. If that's what you need, then you're going to be looking at a very narrow definition of what is abuse. If you can show that abuse and show evidence for that narrow window, then and it's serious, then you need to talk to an attorney and you need to be able to see if you can put this together. Most of the time, what we're going to be looking for is physical abuse, some form of sexual abuse, manufacturing meth around the child, either in their home or in an area where the child is very likely to occur, or emotional abuse. And I want to focus on emotional abuse because the emotional abuse definition is really tricky. A lot of people will think, oh, this child witnessed this traumatic event that was caused by the person. Therefore, it's emotional abuse because I see emotional abuse of the standard form that they gave me. That is wrong. Emotional abuse in this is something where a guardian, a parent, or a caretaker of a child sees the child suffering from some sort of mental health condition and fails to act. Knowingly does not take that child to counseling, knowingly does not get that child set up for medical treatment, knowingly does not do what they're supposed to do. Whether they can't or won't, primarily, the only exception is if they can't afford it for some reason. And even that's going to be sticky because normally, if it gets really bad and they just can't afford it and that child needs services, there'll probably be some sort of CPS worker that will get involved and try and help them get access to government programs and so on and so forth. But if you have a situation where there's a child clearly suffering some sort of emotional or mental health trauma, and the parent or guardian is refusing to act to help that child, then that will be enough to get that. It's not enough to just cause emotional trauma to the child. This is something, or most of the times when I get appointed as a guardian ad litem for a child abuse restraining order, it all falls apart. The child witnesses something horrific and tragic, but they're not physically injured from it. And the petitioner will come in and say, but there's emotional trauma. And the first question I'll ask is, okay, are you taking the child to counseling? And they'll say, yes. And at that point, their child abuse restraining order has basically failed. The child is getting treatment. No one's stopping the child from treatment. So the child abuse restraining order isn't there. So if you're going to go in that angle, you're going to need specific facts. You're going to need to be able to prove them. The most common area is going to be the family court. This is going to be situations where you talk to Attorney Bolter, you talk to Attorney Schlemmer, or myself. We will help you talk about modification of your physical placement and child custody order, legal custody order. In fact, if you're wondering more about that, on our Facebook page, Attorney Schlemmer has done a great video about what to do and strategies for modifying this. That's going to be very similar to what we have here. In this case, though, if you're dealing with abuse and you are a parent of the child, and I want to stress that, you're a parent of the child, and the other parent is the one causing this, or the other parent is failing to do something to address a problem. So they have a friend over that's doing something very, very bad to this child, and they're not responsive in fixing it. The new stepmom or stepdad is beating up on the kid, and you need to do something to stop that, and the other parent isn't doing something to stop that. Then the family court is probably going to be the best option. The family court is going to have the widest arrangement of options, and the main reason why goes back to the constitutionality of parenthood. Whenever we have a situation where a third party, like a outside person or government, tries to come in and disrupt that relationship between parent and child, there's going to be very high standards. You're going to have to probably show some form of unfitness to interrupt that parent-child relationship. But if it's another parent and we're just trying to balance out the constitutional rights between the parents, then we can shift and look mostly at the best interest of the child. We're not really stepping on the constitutional rights of any one party. We're just managing and balancing it under the facts for the best interest of the child. So the family court is going to have the most flexibility in this. Now, if you're going to be doing this, again, watch Attorney Schlemmer's video, but keep in mind, if there's going to be abuse in that, you're going to want to talk about that parent-child relationship, how that's toxic and abusive, and the negative ramifications to the child. This isn't going to be a wrestling match of who's the better parent or who gives the child the best opportunity. That's literally not what the courts are going to be looking at. They're going to be looking at how do we balance out that parent-child relationship. That's going to be very, very important because they're going to have a constitutional duty to protect that. If you've got evidence that that's what's causing the major problems, that's what needs to be focused on. And as you do that, you'll be able to narrow your focus into that abuse and show that ramifications to be able to further your option. You'll be able to look at supervised placement. You'll be able to look at restricting legal custody. You'll be able to look at maybe even denying physical placement in really extreme options. But if there are two parents that both have those constitutional rights, the court has more flexibility to create options between those two. The third option is something called a guardianship. A guardianship is where a third party who is concerned can come in and essentially take parental authority from the parents. This is going to be tricky. This is going to be a bit like the government coming in and doing it. The processes are going to be similar. If you have a private party, as of August 1st of this year, that is going to be entirely governed by Wisconsin Chapter 48. Again, the Children's Code. We're going to be getting a big facelift on that here in Wisconsin. It's going to be great. There are going to be 4 basic forms of guardianship. The first is called a full guardianship. That is where it is a full, permanent transfer of powers from parents to guardian. In this case, you have to show unfitness. You have to show this by a high standard of evidence, and you'll either have the parents sign off so they waive their rights, or there's going to be some sort of contested hearing, which I promise is not going to be pleasant, that will talk through and prove that the parents are not fit to parent. Similar is something called a temporary guardianship. A temporary guardianship is a case where it's not permanent that the parent is going to be unfit. There's some sort of temporariness to whatever they're in. They just fell into a coma, or they're going to be going away for 6 months, or something has gone wrong where they can't parent, and you can prove that they can't parent for a small window of time. It's going to end. We expect that it's going to end, and you can show that. In this case, the temporary guardianship can go up to 180 days. It can also be extended for an additional 180 days, but nothing beyond that. Again, similar to the temporary, is something called an emergency guardianship. An emergency guardianship is there is some sort of emergency situation that we have to address right now. This one has got even lower standards because the court can move quickly to address the emergency, but as a result, it's limited in its time frame. So it can only go for 60 days. The last new one that gives a different sort of standard and might present the most options to people is something called a limited guardianship. A limited guardianship doesn't actually require a finding of unfitness. Instead, it just shows that the parent needs some sort of help. The parent doesn't have the resources, doesn't have the ability, doesn't have the willingness to actually fully parent that child. So they're going to get grandma or auntie or my buddy across the street to be able to fill in that gap and give some of their power to the guardian, but retain some as well. So this is going to be limited in scope. We're going to name the specific powers that the guardian can have and exercise, and it will have a limited time frame. So the court must put in a time frame to say, okay, it'll last for 6 months, 2 years, 3 years, whatever, and then it will sunset, it will end. Now, the court can extend it, but you'd have to show good cause. This is why when I say in your threat assessment, as you understand what's going on, do I need law enforcement here now? Do I need to have CPS start looking around? Or do I just have that uneasy in the gut feeling and I think something needs to be done? I've tried talking to the parents about it, but they're not doing anything, and this is persisting, and this kid is suffering. Talking with an attorney to go through these solutions to understand where you are at, what's called standing, the ability to bring a lawsuit you have to be able to bring this, and what is going to be the best strategy to be able to put something in place is there. Oftentimes in this, I hear people talk about the system, and what happens is this. You have a situation where it rises to a tough thing for a child. It's bad. Everybody knows that it's a bad parent, but it doesn't quite rise to the point where CPS needs to get involved, and then people start running out of options. This is why talking to an attorney is going to be so important. You can look at the options and try to figure out a solution because the system does have things in place. It doesn't always make them easy, but at least then you can know what can be done, who you need to talk to, and how you can set this up to be able to protect the children in your life. Now, if you've heard something about this, if you're curious, please feel free to contact me, Attorney Devin Shanley at Peterson Burke and Cross. Also at our firm, we've got a wide range of legal solutions that we can offer you. Whether you're injured, whether you're dealing with some family strife, or you're looking to deal with these sorts of emergency problems, either with future planning or if you need some sort of response with a guardianship for children, adults, or if someone has passed away and you need to start a probate action. We can offer very good legal solutions for that, and we'll sit down with you free to talk about that because here at Peterson Burke and Cross, we specialize in you. Thanks for joining.